Welcome to this final video on Chapter 8 about title assurance. Perhaps in an ideal world, people would never sell what they didn't own completely without disclosing all encumbrances. But you know that in a regular residential property purchase funded by a mortgage, the bank or lender will require title insurance just in case the title being purchased is not as good as it should be. It usually will be purchased by the buyer, even in a cash sale. Our book states that a prudent buyer in any real estate transaction will insist on any two of the three common means to protect people from buying property the seller does not have a complete ownership and authority to sell. But that's not quite right. Nonetheless, all three methods, title insurance, title opinions, and title covenants, are very important. We'll address title insurance a little bit at the end of this video, but the book does a good job in covering it. Title opinions are written by lawyers or others working for them and describe what those people learn in doing a thorough title search of all public records, the property records in the county recorder's office, probate records, divorce records, judgments against the seller, and sometimes more. Title opinions today are more commonly used for commercial transactions. Then we've got title covenants, which are those promises included in deeds except for quitclaim deeds. There are three basic types of deeds: general warranty deeds, special warranty deeds, and quitclaim deeds. After the closing, the promises a seller may have made in the purchase agreement, including the promise to provide marketable title, are said to have merged in the deed, whichever type of deed is signed at closing. Which one you will choose for a residential real estate purchase probably depends on what is most common in the area where the house is. But the general warranty deed makes the most promises to the buyer. In other words, there are more ways for the seller to incur liability after the sale with a general warranty deed than there are with the other two types of deeds. On the other end of the spectrum, in a quitclaim deed, the seller makes absolutely no promises about title to the buyer, and the special warranty deed lies in the middle. No matter which one is used, the buyer should have an excellent title search done to prevent buying a property with clouds on title. There are also statutorily approved short forms for these deeds in many jurisdictions, which means that a short form of either the general warranty deed or the special warranty deed will be deemed to include the corresponding warranties, even if they themselves are not recited right there in the deed itself in black and white. The basic differences between the general and warranty deeds are the scope of defects the seller or grantor warrants against. For a general warranty deed, the grantor warrants title against all defects, whether they arose before or after the grantor got title. In contrast, in a special warranty deed, the grantor warrants title against any defects that arose after he or she got title. In other words, against the grantor's own acts only. And in a quitclaim deed, the grantor makes absolutely no promises at all. The quitclaim deed says that the grantor is giving the grantee whatever the grantor had, nothing more, nothing less, and no warranties about what it might be. Both the general warranty deed and the special warranty deed make these three present covenants: of season, of right to convey, and against encumbrances as of the time of closing. These covenants are breached, if ever, only at the time of closing. The statute of limitations will start to tick on claims for breach of these three covenants from the time of closing. The first two covenants, season and right to convey, at this point are pretty close to synonymous. The covenant of season is a promise that the grantor owns the estate the grantor purports to convey. It would be breached, for example, if the grantor promises to convey a fee simple absolute, but it is later discovered that the grantor only ever owned a life estate. The covenant of right to convey is a promise that the grantor has the right to convey title. In other words, no one else's authorization is required to transfer the property. The covenant against encumbrances is a promise that there are no encumbrances on the title other than those expressly disclosed in the deed. So we're talking about unresolved and undisclosed mortgages, liens, easements, and whatnot. The future covenants also are present in both types of warranty deeds. The future covenants are breached, if ever, after the grantee takes the property and finds themselves facing a lawsuit, actually or constructively evicted, or otherwise damaged because of an undisclosed title problem. Again, the first two, warranty and quiet enjoyment, are basically merged. The covenant of warranty is a promise that the grantor will defend the grantee against any claim of superior title that someone might someday bring. The covenant of quiet enjoyment is the grantor's promise that the grantee's possession of the property will not be disturbed by anyone holding superior title. And the covenant of further assurances is the promise that the grantor will sign documents and take any future steps necessary to clean up title should a defect be uncovered in the future. Again, the difference between the general and special warranty deeds is that to all 6 of the covenants, the grantor on a special warranty deed makes these promises only as to something that happened during the grantor's ownership. The general warranty deed goes further and makes the warranties for anything that might have happened even before the grantor came to own the property. Now, the Brown versus Lober case illustrates how the statute of limitations starts to tick on present covenants at the closing, and the norm on future covenants is a 10-year statute of limitations. In this case, too much time had passed by the time the plaintiffs realized that they were short on the mineral rights promised in the mineral deed because of an undisclosed 1/3 interest in those subsurface coal rights. But no one had tried to sue or evict the plaintiffs, so they were also premature in trying to assert a breach of the future covenants. So they didn't get all of what they bargained for. There was a breach of the covenant of season, but this lawsuit is not going to make them whole for the gaps in the title search they presumably paid for. If someone does come and assert that 1/3 interest, then the future covenants of general warranty and quiet enjoyment will be breached, and the grantor will have to pay to defend the suit and possibly compensate the plaintiffs. Constructive and actual eviction means literally that the buyer can't use the property. Finally, a note after the case does an excellent job describing the measure of damages in these cases. Note also that the future covenants will run to future grantees, meaning that if the property is subsequently sold, the new buyer could sue the old seller when those future covenants are breached. But the majority rule is that present covenants still do not run to future grantees. What fills these gaps? Title insurance, of course. During class, we performed a basic title search. Every title search will start with an index. In a very tiny minority of jurisdictions, you will still find a tract index, which organizes information by property using a unique parcel identification number, PIN, for each lot. There are still some old tract deeds in Hamilton County and near Cleveland, and tract indexes can still be found and still in current use in Hawaii, Minnesota, and Massachusetts, but they are not common. Australia uses a version of this known as the Torrens system, which I'm not going to address here. Almost universally throughout the United States, all property has been indexed only through a grantor-grantee index system. The starting place for every title search is the last name of the person selling or wanting to grant the property. Let's assume your client is wanting to buy a property from Sandra D, and you are going to do the title search yourself instead of relying on a title insurance company to do it for you. The first thing you would do is go to the grantee index and look up Sandra D by last name to find out when and from whom she got the property. Then you would repeat this process for whomever sold or gave it to her all the way back for 30 or 40 years, depending on what is required under the Marketable Title Act in your jurisdiction. Let's say it's a 40-year jurisdiction. Once you research who owned that property going back 40 years, that's called your root of title. As you find this transfer, you would then switch over to the name in that root of title and come on down the grantor index and do the same thing, switching the name that you're searching with each new transaction in most jurisdictions. In some jurisdictions, however, you have to search each name in the grantor index from the time that they got the property all the way to the present. You would find more problems that way, potentially. This is a more complete title search, but in most jurisdictions it's not required, but it is in a sizable number. So let's say you followed your jurisdiction's rules and everything looks good. Every lien has a record that it's been paid off, and any easement that you find is something that your client is happy to live with at the market price that your client agreed to pay, Sandra D., then you would say that the chain of title is clear. On the other hand, if coming down the grantor index, the search reveals a conveyance to someone outside of the chain of title in the grantee index, then we have a problem. A stranger seems to own an interest. You'd have to make sure the statute of limitations has run on it, or get that cleared up before recommending to your client that he or she purchase the property. And definitely you must disclose that to your client. Also, chances are Sandra D. will have a mortgage. You'll find it when you search from her name up to today in the grantor index. You would insist, of course, that it be paid off at closing using the proceeds your client brings to the table. But its existence normally is not a reason to shy away from the property unless the amount is more than what your client is saying he or she is willing to pay. What I've described is the very basics of a title search. In a perfect world, someone would go and read every single one of the documents itemized in the index. That's definitely what you would do if you were writing a title opinion. But today, the title companies have computerized much of what exists in any given county, such that they will not necessarily have to go back and read everything today before issuing a title insurance policy. Many of the counties now have computerized records, but only on a prospective basis, meaning that they started computerizing all things recorded after a certain date, but did not have the funds to go back and computerize everything from the time the county started a recording office. That money is not likely to be forthcoming anytime soon. The title companies have become the norm because they have done what the government had an opportunity to do to save a lot of money on a macroeconomic basis, but never did. Some people think blockchain could be used to supplant title companies. I'm really interested in that idea, but we'll see. The purpose of the entire recording system is to provide a means to protect bona fide purchasers who do title searches at the purchase stage, and later by encouraging them to record their title so no one else can come along and act as a bona fide purchaser against them. Generally, recorded documents put the world on notice as to the interest conveyed in the document. But there are exceptions, and of course you should remember that adverse possession interests often go unrecorded. Luthi versus Evans highlights the limitations of the recording system and how different jurisdictions' rules will impact what people find in a normal title search for the jurisdiction. People are considered to be on record notice as to everything a normal search in the jurisdiction would reveal. So, loosely, the purpose of the Recording Acts is to allow a bona fide purchaser to win out over a first-in-time grantee who failed to record and put the world on notice of his or her ownership. But the first-in-time needs to properly record to put the world on notice, and Luthi versus Evans shows how a Mother Hubbard clause would not do that unless the jurisdiction requires someone performing a title search to investigate every conveyance from a common grantor within the county. And about half of the jurisdictions do require this. But only then, when someone pulled the assignment of interest in oil and gas leases signed by Grace Owens and read it, would someone have seen the Mother Hubbard clause in the lease and then effectively been put on notice that Grace Owens gave away everything she owned in Coffee County. And then the person would have to figure out that that included the Kufal lease. If the jurisdiction did not require such an extensive search, and Coffee County, Kansas in 1978 did not, then someone buying the Kufal lease from Grace Owens would do a basic title search specifically as to the chain of title in the Kufal tract only, and would not find Grace Owens' transfer to International Tours because it was never recorded specifically as to the Kufal tract. Now, International Tours might be able to sue Grace Owens for breach of the covenant of season, but that's a completely separate matter as to whether J.R. Burris can qualify as a bona fide purchaser and strictly satisfy the Recording Act to knock International Tours off its first-in-time perch. Because a regular title search in the jurisdiction would not have revealed Grace Owens' Mother Hubbard Clause conveyance to International Tours, J.R. Burris was not put on notice of the conveyance, even though it was recorded. It did not contain a legal description of the Kufal lease, and thus J.R. Burris never would have found it. Thus, J.R. Burris can qualify as a bona fide purchaser. International Tours should have completed its research before the transfer, or if that wasn't possible because this was a deathbed transfer or something along those lines, then ASAP thereafter, and used an affidavit to clean up the title records and put the world on notice about its interest in the Kufal lease, which was in fact in Coffee County. A final note from this case is that if a document has everything it needs to be properly recorded, and it's the Register of Deeds' fault that the document is improperly indexed, the party who sent that document for recording will get credit for having recorded the document and put the world on constructive notice. Nonetheless, to avoid litigation down the road with a wannabe bona fide purchaser about whether it was the clerk's fault or yours, it's a good idea to make sure you have confirmation of proper recording of every real estate transaction you're involved in, either as a buyer or a seller. Again, the purpose of recording acts is to give people faith in the market that after they do a routine title search, they could feel comfortable, at least with some title insurance, to go ahead and buy property. It incentivizes people to properly record their interests to prevent some other bona fide purchaser down the road from coming in and strictly satisfying the jurisdiction's Recording Act and pushing a first-in-time purchaser off his or her perch. There are 3 different types of recording acts. The pure race statute says that whatever a purchaser records first wins. We don't care about what the purchaser knew. This type of statute screams out to everyone, record your deeds and fast. It exists just in North Carolina and Louisiana today. Then about 1/2 of the remaining states have a pure notice statute, and the other half have a race notice statute. Pure notice statutes say that bona fide purchasers for value without actual record or inquiry notice of the first-in-time's claim wins. So everyone should still record immediately to put people on record notice. Then there are the race notice jurisdictions. There, a bona fide purchaser for value must both lack any kind of notice and win the race to the clerk's office to record. What Messersmith versus Smith demonstrates is that for someone to record a document, it must be properly recorded under the jurisdiction statutes telling the county recorders what they may accept for recording. At a minimum, every document must be acknowledged in front of a notary. Unacknowledged deeds are patently deficient, meaning that we can see that they're not notarized, and they're not supposed to be recorded at all. The problem in Messersmith was the grantor's signature was not performed in front of the notary, but the document was later properly notarized. Notarization is where the notary swears or affirms that someone has produced identification or is personally known to them and was in fact the person who signed that document right in front of them, and the notary is going to stamp it and sign it. So Messersmith is in the book just to help you understand how things work. The Zimmer rule highlighted in that case really should just die, and it almost has. The case really highlights to you how unsure people would be. They'd be really a little afraid every time they tried to buy property if the Zimmer rule were still to be in effect. And a result of that would be that title insurance would cost a whole lot more in those jurisdictions. So even under the Zimmer rule, this court limited the application of that rule greatly. And I'm not too concerned if you 100% understand it, as long as you fully understand what recorders are supposed to do in the recording office. They don't do research and make sure everything lines up. If something satisfies the jurisdiction statutes for what can be recorded, the recorder's office takes it, scans it, and indexes it, and files it chronologically. The majority rule is that we want people to have faith in the market and pony up their cash. So the majority rule is that for latent defects like this, but not for forgeries, that's an exception, but for all these other latent defects that you can't tell from looking at the document on its surface, we treat it as if it is in fact properly recorded. For forgeries, the bona fide purchaser is sadly out of luck and will be stuck, although perhaps with a claim against the title insurance company. Even though when it comes to forgeries, we can't tell that we're looking at a defective document either. A forged deed is a void deed, and the bona fide purchaser down the chain of a forged deed is out of luck. In contrast, if someone gets a deed from someone else who induced the seller to sign a deed by fraud, that's fraud in the inducement of the contract, that kind of deed is voidable. But if a bona fide purchaser doesn't know anything about that fraud, that bona fide purchaser can take advantage of the Recording Act if the true owner doesn't void that deed before the bona fide purchaser buys the property. Raub versus General Income Sponsors demonstrates this principle, and I hope that this slide helps you nail down where to categorize things. Let's do the problem in Note B after Messersmith versus Smith in order to really nail this down. So we have listed in chronological order the key events that occurred in this chain of title. Carolyn conveys to Frederick first, then she seems to be a dirty double dealer and conveys to Smith. Smith then conveys to Seal. Carolyn and Smith are out of there. They've conveyed their interest, aren't claiming anything. Then Smith records, then Seal records. Then finally, our first in time, Frederick records. So the two fighting, we already have a Frederick and Seal, and we already have that Frederick right here at point number 1 is clearly the first in time. So the person who needs to take advantage of the Recording Act is Seal. So who won the race? You see right here that Seal won the race. And because Smith had recorded before Seal, Seal was not a stranger to title either. Then we have to ask ourselves for a notice jurisdiction. Did Seal have any notice of Frederick? And on these facts, absolutely not. If Frederick had recorded before Seal recorded, that would have been different. And then we would have found it in here in particular. But without that, Seal recorded first. Seal had no notice, so Seal would win in a race jurisdiction and a notice jurisdiction, and of course also in a race jurisdiction. Notice also that Frederick, as the first in time, maintained priority up until this point 5. Even though Seal became a bona fide purchaser at point 3, Seal didn't solidify everything that needed to be done under the statute until the recording. Before we do more problems, we need to make sure that everyone understands the shelter rule. Under the shelter rule, a bona fide purchaser transfers protection earned under the Recording Act to any later grantee from that bona fide purchaser. In other words, the later grantee of the bona fide purchaser steps into the bona fide purchaser's shoes. And that's true, no matter what we might know or about what was wrong and what was the problem. If somebody's a bona fide purchaser and transfers to somebody else, that someone else takes their status, even if by that point they're fully aware of title problems. Now let's do the problems one by one in Note F after Messersmith versus Smith. So in chronological order, S conveys to B, so that's our first in time, who does not record. Then S is a dirty double dealer and conveys to C. C records first, then B records. So again, the first in time is B. So it's up to C to try to take strict advantage of the Recording Act in order to push B off the first in time perch. If we are under a pure race statute, here you see that C recorded first, C wins the race. If we're under a pure notice statute, we have no indication that C had any information about B before this conveyance here in number 2. So C would also win in a notice jurisdiction, and winning in both, C also would come out up top in a race notice jurisdiction. So let's look together at this second problem. S first conveys to B, who is our first in time. Then S, sort of like a dirty double dealer but not taking cash, conveys to C as a gift. The problem with gifts is that no one who receives property as a gift can qualify as a bona fide purchaser for value, which is the standard for what's required under every single jurisdiction's Recording Act. Therefore, C, being the one who needs to take strict advantage of the Recording Act in order to push out the first in time, loses in every jurisdiction. Here, the first in time cannot be pushed out, so B wins in every jurisdiction. So let's look at this one where we have 3 claimants to the property because none of them has transferred away their interest. S conveys to B first, who does not record. B is our first in time. Then S acts as a dirty double dealer and conveys to C, who does not record. Then S acts as a triple dirty dealer and conveys to D, who does not record. Then C records first. In a pure race jurisdiction, C can knock off that first in time because C won the race. So in a pure race jurisdiction, C wins. But in a notice jurisdiction, this highlights why C really should have recorded promptly right in here. If C had done that, then there's no way when D came along that D could have claimed not to have any knowledge of a conveyance from S to C. So in a notice jurisdiction, D pushes off the first in time, both of B and of C, and D takes the property. In a race notice jurisdiction, however, D didn't record before C, so D did not win the race. So in a race notice jurisdiction, C is the only party who can take advantage of the Recording Act and push off the first in time, B. So this problem highlights the shelter rule in action. Let's look together. First, S conveys to B, who does not record. Then S is a dirty double dealer and conveys to C, who also does not record promptly. Then C finds a buyer in D and says, listen, there's this issue that's come about and this other person claims to own the property. So B is claiming to own it, but I'm the owner of the property. And D goes ahead and purchases it. So C records and then gets out of the picture, has conveyed, isn't interested in keeping any stake. And then B comes along and records, and then D comes along and records. So our first in time is B. So the party who needs to take strict advantage of the Recording Act is D. Now it looks like under this that because B recorded before D, that D couldn't possibly win, but that's not accurate. It's C who won the race. And under the shelter rule, because C won the race and D comes in and steps into C's shoes, D is also said to have won the race. Now, in a notice jurisdiction, the same thing happens because it's not whether D knew about B, but it's about whether C knew about B. Once C bought the property with no knowledge as to B, then C satisfied the notice jurisdiction, right, Recording Act, and therefore when D comes in and purchases, D is going to step right into C's shoes, and D is likewise going to win in a race notice jurisdiction. I want to briefly go over the chain of title problems in Note E after the Messersmith case with you as well, just to highlight a couple of the problems that are common in title issues. So let's say that you represent D, okay? And D says, could you do a title search so that I can find out if I can buy the property from S? And what you would do is you would start in the grantee index under S's last name. And so from there, in the grantee index, you would go up, back from the date where S got the property, which is somewhere up in here, right? Up above where S is able to transfer for the first time. That means that you'd go back 30 to 40 years from there, and only then would you switch over and come down the grantor index. And you would be looking in the grantor index from the root of title back 30 to 40 years, and then you get to the point where S has the property. And then what you're going to look for is any transfer that's recorded from S to somebody else. So here, even though C recorded, you wouldn't find it because C got the property from B and not from S. Here, when you're coming down the grantor index, the only name you have is S. So you wouldn't find this deed from B to C, which is recorded because it's a stranger to S's name in the title. Therefore, D would feel safe in buying the property and record and secure the title. So in the last scenario, we had the wild deed scenario where that BC deed, that has nothing to indicate there was some problem with it, but when it was recorded, it wasn't findable in a normal search. So it wasn't properly recorded for the purpose of a title search. And the same can happen when a deed from a transaction is recorded too late. So here we have S conveys to B, who does not record. S conveys to C, so S is a dirty double dealer. And C has actual knowledge of B. But C records first, then B records. Then C conveys the property to D, and D records. So if we had a challenge between D and B, what would a title search look for D, who's the subsequent purchaser who's going to check things out? So D is looking to buy property from C. So D is going to search in the grantee index going up under C's name. So C's name is in the records, and this would be found. So what D would see is an S to C deed at this point. So D would find C's name, then switch to S here, and keep going back for 30 to 40 years, and then come back down the records on the grantor side. So let's say everything checks out and we get to S. If you look in the records, D wouldn't find anything before C. The first thing that B would find is the S to C deed that's recording. And then in most jurisdictions, we switch over to C, and there being no other transfers from C before D comes along, you'd say to D, yeah, title's clear, go ahead and buy. So in jurisdictions that say that we switch each time we get a new name, this B deed is recorded too late. It needed to be recorded in here before C got the interest in order for D to find it in a normal title search for the jurisdiction. So in a minority of jurisdictions, there's a more extensive title search that's required. They require the title searcher to look under each grantor's name from the time the grantor received the title all the way to the present. So we wouldn't stop here with the S to C transfer, we'd go all the way to now. So in those jurisdictions, this deed would in fact be found. And you'd have to tell D, nope, there's a cloud on title and you can't buy this property unless it's cleared. Let's say for this problem that B is a big-time real estate investor and finds somebody who wants to buy a property and says to that person, C, listen, I am about to have a property ready that's just beautiful and the price is going to be $150,000. And C says, that's right in my range. Can I see the pictures and what it's supposed to look like when it's done? And C loves the house. And C says, great, I will buy it for $150,000. And maybe it's done as an installment land contract so that there is no bank involved that would insist on there being a title search and title insurance. So B goes ahead and signs a deed conveying the property to C. And let's say that happens before B finalizes a cash purchase of the property, which is called Greenacre, from S, the seller. So let's say that was to be a quick cash purchase, but it took a little longer than anticipated, and B went ahead and signed the deed with C anyway. So in the beginning, S owns Greenacre, then C is the one who is interested in buying the property and talks to B, and they go ahead and sign a deed here prematurely before the transaction from S to B is even finalized and recorded. And then it turns out that B is a dirty double dealer to boot. So B then goes ahead and sells the property again to D and takes everybody's down payment and splits town. So then in the end, the fight is going to be between C and D, right? The two who are left holding some interest that they both want to maintain. So the question is, C is the first in time, as between C and D. Can D take advantage of the Recording Act to push off the first in time of C? So the question again is, doing a title search, would D have been put on notice as to C's interest? And in terms of C's interest, yeah, it's recorded first up here, but is it properly recorded? And the answer is, as of this point when it's recorded, there is nothing that links C to S, who was listed in the documents as being the owner of the property. So it's not properly recorded. So under a race jurisdiction, D wins. Now let's think about what D would see in doing a title search from B, who is the property owner, as far as he knows, right? So D would look in the records and see, oh yeah, okay, so B is trying to sell me the Brooklyn Bridge here, known as Greenacre, and B has a deed from S. At this point, we switch over to looking for S, and keep going back the 30 or 40 years. We wouldn't know anything about C to look in the title records. Once we get back the 30 or 40 years, we switch over to the grantee index, and let's say we come down, from the root of title, and then we get to S, and we look for where S first makes a transfer. That point is here. It skips over C, who is still a stranger to the chain of title. So D would then see that S has no other conveyances up until the present time, and you'd say to D, yeah, the title's clear, go ahead and buy it. So this problem illustrates the issue of C recording too early before the interest that B was conveying was locked down in the records. For this problem, deed from a common grantor, let's assume that your client is C. In most jurisdictions, but it's only a slight majority, your client needs to have a title search run on only the property that your client is buying. So here, that property is Forest Acre. So in this scenario, if S owns both properties, let's say they're right next door to each other, maybe they were both joint at one point, but they were subdivided. S owns both of them, and S conveys one, Greenacre, to B, but granting an easement to cross Forest Acre for the purpose of accessing Greenacre, and that's all in the deed that relates to Greenacre. So this easement to cross the property that your client is interested in buying isn't mentioned in any deed that S has as to Forest Acre. It's only mentioned in the Greenacre deed. So this other person buys Greenacre, gets this easement across Forest Acre, and records it. Then your client comes along and wants to buy Forest Acre and doesn't know anything about the easement, and doing a title search only as to Forest Acre wouldn't find it. So your client would come in and record it. But in a decent number of jurisdictions, your client is responsible for doing the title search not just as to Forest Acre, but as to all property that S owns in the county. And if that's the case, assuming that we don't have any strange county lines dividing these two properties, your client would have found the easement that runs across Forest Acre, been on notice of it, and if your client purchased the property, would purchase it subject to that easement. So Board of Ed versus Hughes is a funny little case. This is the case where the Horgers sold property to Hughes, and they sent over a deed, but they didn't sign it, and Hugh didn't put his name in it right away until right before he wanted to record. So Hughes signs and records the deed is here at point 5. Now the court ruled that until that deed was signed, that transaction really didn't occur. So what happens here is that Hughes is entitled to be looked at as a subsequent purchaser to Doria and Wilson, and then the Board of Ed, who purchased from the Doria and Wilson in between the time of that initial sending over of the $25 check and the sending over of the deed with the blank line for the signature. So the Horgers, maybe they're dirty double dealers, but on the other hand, all they give to Doria and Wilson is a quick claim deed, which is you have everything that I might have, and I don't make any promises of what that might be. And then Doria and Wilson flip the property and sell it to the Board of Ed. And the Board of Ed records too early. It records before Doria and Wilson. So whatever they record is not going to be properly recorded because they are strangers to the chain of title here. There's nothing to link them to the Horgers, who, as of point 2 here, are still the owners of record when you go and look at the title search. Dorea and Wilson didn't record until here at point 6 after Hughes. So the first question that the court addresses is, did the Horger's deed to Hughes become operative? And the answer is yes, but when the name of the grantee was entered by someone who had the authority to insert that name. And therefore, this deed became effective all the way almost 4 years later in 1910, excuse me. So that's one problem. Now the other question is, to win a race in a race jurisdiction, did plaintiff win it here? And again, the issue is the recorded too early problem. This deed is not deemed to be properly recorded because there's no link to the owner in the chain of title in the records. So it was Hughes who was able to use the Race Notice Recording Act to push off the Board of Ed, who was looked at as the first in time purchaser, because it was Hughes who got subsequent purchaser status by filling in his name later and then recording, and he did that before there was any proper recording that the erroneous order could have been cleaned up by Dorea and Wilson and the Board of Ed first. So therefore, Hughes wins. Funny little case. Let's go through these 5 more advanced problems in Note E after the Hughes versus Board of Ed case. So the first one, we have S conveys to B who does not record. So B is our first in time. And then you have S being a dirty double dealer and conveying to C who knows about the SB deed. So that means that C cannot qualify as a bona fide purchaser. Then we have B records and C conveys to D, and then D records. So in this case, shelter rule, of course, gives power to B. This problem in the end here is between B and D. D cannot gain classification as a bona fide purchaser under any shelter rule because C didn't have it. So that doesn't come into play. And B had recorded the deed before C. So doing any kind of title search, D would have searched up the grantee index from C and then would have switched and found S. But coming down, let's go back up for 30, 40 years, coming back down the grantee index, searching for S, the first time that there would be any interest in the records would be this recording of the S to B deed. So D would know that there's a problem with C's title. So D also has notice in D's own right, and B wins the race. So B wins in every jurisdiction because D cannot take advantage of either a race statute or a notice statute or a combo to push off that first in time. This one is pretty similar to the last, except we changed the order of the recording of C and B. So S conveys to B who does not record. S conveys to C who knows about the S to B deed and therefore is not a bona fide purchaser for value. Then C records, then B records, then C conveys to D, and D records. So the problem is between B, the first in time, and D. Let's talk first about a notice statute. D owns Greenacre in many jurisdictions. When a title searcher searches the grantee index forward to the present, so we've already gone back, right? D says, oh, I see that I'm buying from C. C has a deed from S. That looks good. And we go back and everything looks fine. But then when we switch over, the person doing the title search will stop searching under S's name when she sees the recording from S to C, and then immediately switch to C's name. So D, doing a title search in that jurisdiction, would say, oh, there's no conveyance from C to anybody else before me. That's clear. So the title search would show a clear title and would not reveal this deed from S to B, which was recorded at a point when the title searcher would no longer be searching under S's name. So the problem here is that the S to B deed is a late recorded deed. Since B's recording is late, it's not deemed proper. And D therefore gains priority as a subsequent purchaser without notice of B's interest. So it doesn't matter that C wasn't a BFP, D was. So in most jurisdictions, D is going to get title as a bona fide purchaser for value with no notice and win in any jurisdiction. And because this B recording was not proper, even in a race jurisdiction, D would win. In a minority of jurisdictions, but it's a small minority, they would require a more expansive search and D would lose. The searcher must look under each grantor's name from the time the grantor received title until the present. So once we get up into here from S and we start to come down the grantee index, then D would find this one, sure, to C, but also would find this one to B. So in this case, the searcher, seeing that S to B deed, would say, we have notice of B's interests, and therefore D could not qualify as a subsequent bona fide purchaser. So B would win as the first in time. In a race notice jurisdiction and an efficient recording system, D owns Greenacre. D is a subsequent bona fide purchaser because B's deed was recorded too late. In addition, B's recording is deemed not to be proper, and thus D is the first to record. However, in jurisdictions requiring that extended search, D is neither a subsequent bona fide purchaser nor does he record first, and B would win as the first in time. So this problem says S conveys to B who does not record, and then immediately B turns around and conveys to C, and C does record. But there's no link between C and S, who in the title records is the owner of record. So C's deed is wild and would not be found in a normal title search. S is then the dirty double dealer and conveys to D. Then D records, and then finally B records. So in this scenario, first of all, the dispute is between C versus D. Okay, so in a notice jurisdiction, D owns Greenacre because the S to B deed was not recorded. There is no way for a title searcher to discover the B to C deed. Here, this wild one. When the searcher searches forward under S's name, she would not locate any instrument that gives notice of any prior interest. So D is a subsequent bona fide purchaser and therefore gains priority over C. In a race notice jurisdiction, D owns Greenacre too. As noted above, D is a subsequent bona fide purchaser. C's recording is wild and not proper. Therefore, D's recording, it's first in time, and D meets both requirements of the race notice statute. Here we've got S conveys to B who does not record, then S is a dirty double dealer, and conveys to C who does not record, then B records first, and then C records. In a notice jurisdiction, actually first, who's the fight between? Obviously B versus C. In a notice jurisdiction, it would be C who comes along and would be able to use the Recording Act to push B, the first in time, off that perch. When C came along right here, C had no notice of any interest of B's because nothing was recorded, and doesn't need to win the race in order to win in a notice jurisdiction. Now let's talk about in a race notice jurisdiction. We already know that C wins in a notice jurisdiction, but does C also win the race? And here you can plainly see that C's recording, which is proper, comes after B's, and C therefore does not win the race. So in a race notice jurisdiction, B stays on top. In a pure notice jurisdiction, C wins. Here we have S conveying to B, but B doesn't record. Then S is a dirty double dealer and conveys to C, and C does record. Then B records late. Then D comes along and approaches C to buy the property, and let's say C tells D all about the S to B deed. Can D still win over B, which is who the fight's going to be about? So B is the first in time, but can D take advantage of the Recording Act in order to push out that first in time? Now here the issue is the shelter rule. Under a notice jurisdiction, C right here bought the property and would win under a notice jurisdiction. Similarly, C won the race, so C would also win in a race notice jurisdiction. When D comes in and purchases this, D steps in the shoes of C who won under the Recording Acts, or would have won under the Recording Acts as a bona fide purchaser with no notice, who won the race. So it doesn't matter that D knows about the S to B deed. In fact, you'd probably prefer that somebody did. Once somebody would win under the Recording Act with this prior purchase, as is what happened here with C and then C recording, the market says that other people can come in and safely purchase from C because C strictly satisfied the Recording Act as a bona fide purchaser. So the answer is that D would win in any jurisdiction because D gets shelter from C's status under the Recording Act. The book does a great job of explaining the basics of title insurance, but I want to explain to you how a basic Alta owner's policy works. First of all, any ambiguity in the policy is construed against the insurance company or in favor of the insured. It's the other way to say it. And all of these Alta policies are basically the same. Okay, so there's a cover page, and then you have Schedule A, which sets forth the name of the insured party, the maximum amount insured by the policy, and what the property is that's insured. Then Schedule B is important. It's specifically accepted things. So things that the title search revealed that were problems or disclosed easements, that sort of thing. Things that are specifically accepted for this property. In contrast, the exclusions, which will be after that, are boilerplate. And these are things that are excluded from coverage for all policies. And then there are conditions, which are just the procedural requirements and how somebody has to go about making claims. So the important thing to remember is that exceptions in Schedule B are what the title search revealed as to this property specifically. And then there are exclusions that are boilerplate exclusions that apply across the board. Title insurance probably doesn't cover as much as people inherently think it does. So there's the duty to defend, which applies when there are cases that come along that, you know, are challenging somebody's right to own the property free and clear. And that is broader than the duty to compensate the buyer for, you know, something that's not an absolute win. So the duty to defend makes sense that it would be broader, and only if that case was won by somebody claiming an ownership stake would the duty to pay kick in. So those are the most important things, I think, to take away from the insurance issues. But I do want you to look at these exclusions, which are in the Riordan case, because this is pretty standard stuff. So I would like you to take a look at that just so that you can understand how this basically works. And then finally, I'd like to say that in a normal residential real estate transaction, it's the bank that insists that somebody buy title insurance. And that title insurance policy that's issued protects the bank's investment in the property. So over time, as the mortgage is paid down, the amount of the coverage also goes down. So for buyers who want to protect their own investment in the property, so the equity that builds over time as a result of paying down the mortgage, and hopefully because your market is increasing, right, where your property is bought, the average price is going up, that requires a separate rider to the insurance policy. And in any transaction that's done using standard forms, that should be clear, but people need to separately elect that and pay a relatively small amount of money in order to get that extra coverage. So that's it for Chapter 8. I hope this helps.